Hello, everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host a litigation update on Merck et al. Versus Becerra et al. Our speaker today is Yakov Roth. Yakov is a partner at Jones Day, where he practices appellate and Supreme Court litigation. Yakov's practice focuses on white-collar criminal law, the First Amendment, including religious liberty, and federal statutory schemes such as ERISA, RICO, and Title VII. He has successfully defended clients against nationwide class actions and pursued challenges to federal, state, and local regulations. If you'd like to learn more about today's speaker, his full bio can be viewed on our website, fedsoc.org. After our speaker gives his litigation update, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speaker, not the Federalist Society. With that, Yakov, thank you so much for joining us today, and the floor is yours.
Thank you so much, and thank you to the Federalist Society for hosting this webinar. And thank you to everyone who is tuned in to learn a little more about this litigation. Now, I know the title of the event referred to a particular case, Merck versus Becerra, but I'm actually going to speak a little bit more generally about the litigation that has arisen out of the Medicare drug price negotiation program that was enacted as part of the Inflation Reduction Act, or IRA, back in 2022. Merck was the first challenge to be filed to that program, but it certainly was not the last. And I'll speak a little bit about more about that later. Disclosure, I do represent Merck in that case. I also represent, along with my colleagues here at Jones Day, Bristol Myers Squibb in its own suit challenging the program, which is now in the Third Circuit. So just as an overview of what I'm hoping to cover, I'll start with some background about the statute, how it works. Then I'll talk about the constitutional claims that have been advanced against the program in court. And then I'll close with a summary of where everything stands now with the particular cases that have been filed and their sort of procedural postures. So I'll start, as I said, with the statute. If you're anything like me and you don't have a deep background in drug pricing, you probably heard about this new negotiation program around when the IRA was first being proposed and debated in Congress in 2022. And if you're anything like me and you get your news from the mainstream media, then your first reaction to hearing about this new program was probably to shrug. You know, what's the big deal? What's wrong with negotiation? Certainly, I understood Medicare is a large player in the market for prescription drugs. So presumably Medicare has some leverage, or would have some leverage if it was seeking to negotiate prices. Of course, the pharmaceutical companies also have some leverage. They generally hold the patents to the medicines that they have developed. And so I think my initial reaction, and many people's, again, when reading about this proposal in the mainstream media, was to say, well, you know, why is this a problem? Get them into a room together, so to speak, and hash out what the fair price should be for the product. Well, let me just say that after having learned about the program from, reading the New York Times or the Wall Street Journal, I was completely blown away when I ultimately picked up the legislation itself and read how it actually works. It's not at all what I assumed based on the media coverage. And I don't think it's what anyone would have assumed based on how the program was described and sold to the public. Now, it starts the way you might expect it to start. Program starts with HHS picking a certain number of drugs that are particularly costly for the Medicare insurance program. And the statute says you pick 10 the first year, and then that goes up year by year, so that they're adding new drugs to the program every year for 15, 20, and so on. The first set of 10 was announced in August of 2023. Statute lays out generally how these should be chosen. There's criteria, there are some exclusions. For example, if there's an authorized generic drug that's being manufactured and marketed, then that you get out of the program. You don't become eligible for the program until 7 years after the first FDA approval. So there are certain restrictions on what gets picked. But HHS picks the 10. And then the next step is HHS is directed to enter into agreements with the manufacturers of the drugs that are chosen. And as part of that negotiation, to work towards what the statute calls a maximum fair price, or MFP, for the drug. So you might ask, why would a manufacturer agree to do that? Why would you enter this negotiation process with the government? And if you didn't read the statute, you might have thought the answer would be, well, if you don't negotiate, you don't reach an agreement on price, then Medicare is going to stop covering your product. And maybe you want Medicare to cover your product. Medicare is a big buyer in the market, after all. You might have thought that was the incentive, but that is not correct. The reason a manufacturer would enter this agreement and participate in negotiations with HHS is that the statute imposes a daily excise tax on all sales of the drug if you don't sign. Now, there's been some debate in the litigation about the exact amount of the tax. The statute includes a sort of confusing formula for how it's calculated. But the way we understand it, and the way Congressional Research Service understand it, and the way others understood it when it was enacted, is that the tax starts at 186% of the total revenue that you take in from the drug. It then escalates over time all the way to 1,900% of the revenue from the drug. That obviously makes it completely irrational for anyone to ever pay this tax, because you are giving up the entire value of the drug and then more on top of that. And so in light of that dynamic and that incentive, not surprisingly, Congress predicted that it would raise a grand total of $0 from this excise tax. The point is to compel and coerce the manufacturers to participate in the program. And indeed, every manufacturer that was selected for the first round of the program did sign the agreement rather than trigger this tax penalty. And that happened in October of 2023. One more detail about the tax penalty that I should mention. The statute provides that it can be suspended for any day during which the manufacturer has no agreements in place with Medicare or Medicaid to provide coverage for any of the manufacturer's products. So what that means is, if the manufacturer chooses to withdraw its entire portfolio of drugs from both Medicare and Medicaid coverage, then it doesn't have to comply with this new program or pay the excise tax. And we'll come back a bit later to the significance of that provision. Okay, so what happens after you sign up to participate in the negotiation process? HHS starts it off by making a price offer. The statute says it's supposed to aim for the lowest maximum fair price. And the statute provides a list of factors for HHS to consider in setting that price, including the R&D costs for the drug, the costs of production of the drug, therapeutic alternatives, and some others. One notable omission is that the agency is not allowed under the statute to consider R&D costs for all of the drugs that did not succeed in becoming important and popular ones with FDA approval and success in the market. And that's, of course, the vast majority of drugs never get to that point. So all of that is taken out of the equation for purposes of setting the price. The statute also doesn't set a floor for how low the lowest maximum fair price can go, but the statute does put a ceiling on the amount that HHS can offer, and the ceiling is set at no higher than a fraction of a particular benchmark price in the marketplace that's referred to as non-federal average manufacturer price. The exact amount of that fraction depends on the type of drug and how many years it's been on the market, but it ranges from, at the top end, 75% of the benchmark, meaning a 25% discount off of that price, all the way down to 40% of the benchmark, meaning a 60% discount. And again, that's just the ceiling. So HHS can't go above that. They can certainly go below. If a manufacturer doesn't like the offer that it received from HHS, it can provide a counteroffer. The counteroffer still has to be based on the limited set of factors that the statute says can be considered. But more important than that, or more problematic than that, the statute imposes a deadline by which the negotiations must end. Well, how do negotiations end? They end with an agreement. So what happens if you don't reach an agreement by the statutory deadline? You may have guessed it already. You have to pay an excise tax. It's the same excise tax that I described before, under which you have to pay the government a multiple of total revenues from the product. And so while negotiations for the first round of the program are still ongoing, the deadline isn't until next month, there's really no surprise about what's going to happen. HHS will make final offers to the manufacturers, and the manufacturers will have to sign on the dotted line because the system is structured to make the alternative far worse so that nobody would ever take it. And just by the way, when I say signing on the dotted line, that's not just a metaphor. HHS has come out with a template contract that says, essentially, we negotiated with Medicare, we reached agreement on the maximum fair price for this product, and we commit to make that price available to Medicare beneficiaries. You have to sign that agreement in order to avoid the tax penalty. What happens when you do sign? Well, the main obligation under these agreements is to provide what the statute refers to as access to the maximum fair price to Medicare eligible individuals who are prescribed the drug. In other words, you need to sell the drug at that discount to the Medicare beneficiaries. In practice, it's actually pretty tricky because of how the supply chain works. If you are a 66-year-old person on Medicare, you don't go buy your pills from the Merck factory. You go to the pharmacy, or maybe you get the medicine while you're at the hospital for a procedure. Either way, there are a lot of middlemen in the process. And so figuring out how to get the discount from the manufacturer to the sort of end purchaser, who is then being covered by Medicare for the cost, that's pretty complicated and logistically difficult. HHS is still trying to figure out how it's all going to work. What is clear, though, from the agency's guidance and from the statute is that you sell a drug and then it later gets dispensed or prescribed to somebody on Medicare. You, as the manufacturer, are obligated to ensure that this statutorily required discount gets effectuated in that transaction. And the principal beneficiary of that is the government, because, again, Medicare is the insurer. Medicare is covering the bulk of the costs of the prescription drug. So if the price gets cut by 30% or 50% or 80%, that means the government is paying less. And of course, that was really the whole point of this program. All right, what happens if you violate the agreement? You might have guessed an excise tax. Actually, no, the excise tax is just designed to coerce you into signing the agreement in the first place. Once you do sign, you're on the hook for civil monetary penalties if you violate the agreement, if you don't do what you're supposed to do, meaning provide access to this special discount for Medicare. Just a couple of final points about the statutory framework before I talk about the claims. Number one, the statute also purports to shield from judicial review many of the core HHS decisions that are involved in the process, including the selection of drugs, the determination of pricing, barred from judicial review. And then the second point is, while the statute itself is not very long, HHS has already come out with at least 3 rounds of guidance totaling hundreds of pages, in some cases explicating the statutory requirements and how they'll be implemented. In other cases, perhaps one might say tweaking what the statute says. All right, that's the statutory background. I think, as that description hopefully show, this is a novel, in many ways unprecedented statute. And it really is a very problematic one for the pharmaceutical industry, because the industry depends on the revenues from the rare successes in order to fund the research and development for all of the many drugs that don't pan out. And so it's not a surprise, in light of the consequences and in light of the unusual nature of it, that this statute sparked a lot of litigation, raising a lot of different claims, because this is an unusual and novel scheme. I'm going to say a little bit about 4 of the constitutional claims that have been advanced in court: takings clause, due process, First Amendment, and Eighth Amendment excessive fines clause. There have been some APA type claims relating not to the constitutionality of the statute, but rather to how HHS has gone about implementing the program in its guidance. That's really beyond the scope of this discussion, although there are some very interesting issues there, including how to deal with or how to get around the statute's bar on judicial review for some of those things. All right, first claim that I'll talk about is the takings clause, Fifth Amendment claim. If the government takes private property for public use, it needs to pay just compensation, which generally is fair market value of the property. Takings law is generally divided into so-called physical takings and regulatory takings. Claims that have been filed so far in this matter have asserted physical taking theories, and they those claims build on 2 fairly recent Supreme Court decisions that injected some new life into this area of law. The first is Horn, or the raisins case, as many know it, dealt with this federal regime that required raisin growers to yield a specified portion of their crop to a federal board, for price stabilization purposes. The board would sometimes resell the raisins and then pass along a portion of the proceeds back to the growers. And the Supreme Court said that was a taking. It was a physical taking of the raisins. They said the amount of payment that you might get at the back end, that just goes to how much you might be entitled to in damages, but it's still a taking. And the court said it doesn't matter that you can stop growing raisins and grow some other type of grape or some other type of crop altogether. That doesn't change anything. Either you're allowed to grow raisins, and if you do, the government takes some of them. That's just an appropriation of property. That's one sort of foundational case, recent case in this area. The other is Cedar Point, which dealt with a California law that required agricultural employers to provide union organizers with access to their property so they could come on and try to organize a union. And the Supreme Court again said that is a per se physical taking, because you are entering the property, this access mandate allows third parties to enter onto the physical property. That is a taking. As applied to this program, the basic gist of the takings claim is that the purpose and effect of the program is to take the drugs from the manufacturers for the benefit of Medicare without paying the market value of the product. And it does that, as sort of I tried to summarize, by threatening to penalize the manufacturers unless they sign these agreements. And then under those agreements, they are required to provide access to Medicare buyers to a price that is below market value. Indeed, it's pegged to be a fraction of market value. And so this functions like a compelled sale at a discount. So imagine a city that's dealing with a homeless problem, and the city passes an ordinance saying, you know, if you're a homeowner in the city and a homeless person wants to rent your basement, you need to provide that person with access to your basement at a discounted rent. Well, that would be a taking. Think back to Horn and the raisins. Imagine instead of taking a share of the raisins, the statute had said every raisin grower has to sell 10% of their raisin crop to the board at a steep discount. It's not really any different from Horn itself, just works in a slightly different way. And challengers have argued that the program here really looks a lot like that. Now, the government, in defending the program, has made a number of counter arguments, but probably the most important is that they say, well, this is a voluntary program. Notwithstanding that tax penalties are used to enforce it and to coerce compliance, they say it's still voluntary because manufacturers have the option of dropping out of Medicare and Medicaid altogether. And this argument actually cuts across many of the constitutional challenges. It's not limited to the takings argument. And it is true that manufacturers don't have to participate in Medicare and Medicaid coverage. What I mean by that is they can withdraw their products, all of their products, from coverage. And as I said earlier, it does have to be all of the products. It's not just the one drug that's been selected for the program. It would be the entire portfolio. And so if you look at it that way, it is possible to frame the program as effectively a condition on coverage under Medicare and Medicaid. And if you frame it that way, that then tees up another doctrine, which is unconstitutional conditions. Can the government do that? And the challengers in these cases have made a number of arguments for why the government cannot do that, why that is an abuse of the spending clause power. The first is it's too coercive, and there is a direct parallel there to the Supreme Court's NFIB decision, the Affordable Care Act decision, and in particular, the portion of that decision that dealt with the Act's expansion of the Medicaid program. The statute had said that states had to expand Medicaid beyond its original scope, or else they would lose funding for the whole program, not just the new piece. And the Supreme Court said that that part of the statute was invalid because it was unduly coercive. You need to give a real choice, not a fake choice or an illusory choice. Now, why was it an illusory choice? Well, the court focused on the fact that this was a new, novel expansion of the program, that the amounts at issue represented a very large percentage of state budgets. So it mattered a lot in terms of the amounts. And because the ACA was leveraging the old stream of money in order to induce the states to participate in this this new expanded program. And actually, the IRA here in the program is parallel to that in all respects. Got a sort of new surprising shift from market-based pricing that had been in effect for decades under Medicare to this government top-down price setting. Affects a huge portion of the market. Medicare and Medicaid together account for almost half of spending on prescription drugs. And the leveraging, that's the all-for-one idea that if you want to, that the only way to avoid participation with respect to the one drug that's been selected is to withdraw all of the drugs that you have in your portfolio. And so there's a pretty stark similarity between the two programs, and the fight in litigation has been, as a result, more about whether NFIB and this concept of coercion applies outside the federalism context at all, and the government tries to limit it, not surprisingly. And challengers say it's a broader principle that draws on the unconstitutional conditions doctrine. Aside from coercion, the other key point here is disproportionality. Under traditional unconstitutional conditions doctrine, you're always going to look to the relationship between the condition and the benefit, make sure they're related, make sure they're proportionate. For takings clause purposes in particular, the Supreme Court has what's called the Nolan-Dolan test, derived, which comes from two cases, Nolan and Dolan, that set up that two-part requirement. You need a nexus, and then you need proportionality between the condition and the benefit. And so if the IRA had said, look, if you don't reach an agreement on price, Medicare is not going to cover that drug anymore, that would be one thing. But instead, as I tried to explain, the statute effectively says that agreement on the one single drug that's been selected is a condition for participation in Medicare and Medicaid coverage for all of your products. That's disproportionate, challengers argue, because it is holding hostage one thing to force another thing. If it wasn't the government doing it, we might say that's extortion. We might say it's anti-competitive in the antitrust context. We think the proper analog to those ideas in this space is unconstitutional condition. All right, that's takings. Takings clause isn't the only part of the Fifth Amendment that's been advanced and implicated by these cases. Another claim that's been raised focuses less on the taking of the drugs and more on the process that is used to set the prices. Rate setting has been around for a long time in a lot of different contexts, but almost invariably there is both a more formal front-end process for setting the rate and judicial review on the back end to ensure that the rate that is picked is fair and reasonable and not confiscatory. The IRA doesn't provide for any of that. And so some plaintiffs have framed that as a procedural due process problem, analogizing to cases from the utility context that do require some additional level of procedural protection when the government is doing rate setting. Other plaintiffs have given this argument a little bit of a non-delegation or separation of powers flavor. You're giving HHS an enormous amount of discretion in this scheme. There's very little in the way of specific guidance on how it's supposed to exercise that discretion. And then there's no review, no potential for review by the other branches, including the judiciary, after the fact. Now, none of this gets away from the voluntariness argument that I was talking about before, and so that piece remains relevant to this framing too. Third claim that I'll talk about is the First Amendment. The First Amendment claim alleges that the program compels speech by forcing manufacturers to sign the agreements under threat of penalties. The agreements really buy into the whole regime because in the agreement, the manufacturer is saying Number one, this is a real agreement, that it flowed from negotiations, and probably most importantly, that the maximum fair price set by the agency is the maximum fair price that is agreed on, which, by the way, means effectively that the manufacturers are admitting that they have been gouging the public with unfair prices up until this point. It almost feels like a sort of forced confession. And of course, we don't usually think of contracts as expressive in the First Amendment sense. Most of the time they're not. But this is pretty unique, both in the expressive content that it includes, and in the purpose for having this requirement. And the way I like to conceptualize that, the purpose, is to ask, why is the program structured this way? Why is it set up so that all of the substantive obligations flow through an agreement? Why not just say in the US Code, HHS has the power to set prices, manufacturers must provide access to those prices or else pay penalties? That would look exactly the same in substance and in economic effect as the regime that this Congress did create. But Congress didn't do that. Instead of ordering manufacturers to do these substantive things, the IRA launders everything through the requirement to agree to those things. So why? Why do it this way? And I think the only answer is the optics, which goes back to where I started with the way the program was sold. People like negotiations. People like agreements. That's the way our economy works. People think it's a good way of doing things. Top-down price setting by a bureaucracy is not as popular, and polls bear that out. And so Congress essentially tried to dress up one as the other. They're doing top-down bureaucratic price setting, but they are masking it with these agreements that make it look like it's the product of voluntary negotiations and agreement. And that really does go, I think, to the heart of the First Amendment and the purposes of the compelled speech doctrine. Now, as with the other claims, you still have you could just abandon Medicare altogether counter argument. But that counter argument is, I think, especially weak in this context because the Supreme Court has been very resistant to conditions that take the form of compelled speech. And the classic case on that is the US AID decision from a few years ago. That was a government program that the government was giving grants, but in order to be eligible for the grants, you had to agree that you opposed prostitution and sex trafficking. And it was actually written as a provision into the grant agreement itself. And the Supreme Court said, no, you can't do that. You can condition how the money is spent, but you can't make the recipient essentially pledge loyalty to government policy as a condition of receiving the grant. And so under that line of cases, I think the voluntariness or conditions response has some big problems. All right, very briefly, one other constitutional claim in the mix is the Eighth Amendment excessive fines clause, which relates to the excise taxes that I talked about. There's not a huge amount of case law on excessive fines, but it does really jump out at you that this excise tax is not a genuine revenue-raising tax. It's projected to raise zero. It's just a way to coerce compliance, and it does that by imposing a fine that is grossly disproportionate to any harm that is caused by the conduct. The conduct is not agreeing to negotiate or not agreeing to a price, and the fine is then this enormous multiple of total revenues from the product. So if you apply the limited doctrinal frameworks that are out there in this space, this tax definitely seems to fail it. It does raise a sort of procedural hiccup, though, because the Anti-Injunction Act limits the ability of federal courts to enjoin assessment or collection of a tax in a pre-enforcement posture. And it is, this tax is labeled as a tax, so the government has the ability to say, you can't bring this, you got to actually pay the tax first and then sue for a refund. And so in order to get around that problem, the challengers need to either explain, actually, this is not a suit for the purpose of enjoining a tax. It's really about enjoining the substantive mandate that the tax is enforcing, or alternatively invoking one of the exceptions to the AIA. There are a couple limited exceptions that have been recognized. All right, that's a summary of the major constitutional claims that have been advanced in connection with this program. And so I thought at this point I would give a little overview of where things stand right now, where they're headed in terms of the active litigation. One sort of big picture point to keep in mind is that the prices for the first round of the program, the drugs that were picked in August of 2023, those prices take effect in January of 2026. And so you can sort of view this litigation as moving towards and seeking definitive resolution at the appellate or more likely Supreme Court level by January 2026, when this program will actually kick in at the economic level. As I said at the outset, the very first case that was filed was by Merck. That was filed in June of 2023 in the district court in DC. It was assigned to Judge Collar Catelli. Summary judgment briefing by both sides was completed just after Thanksgiving in 2023. So those briefs have been sitting for a while. No hearing has been held, no decision yet. Hopefully that will be resolved soon, and then we'll be headed up to the DC Circuit. A number of cases were filed in the District of New Jersey. That's where a good chunk of pharmaceutical companies happen to be headquartered. So we had Bristol Myers Squibb, Janssen Pharmaceuticals, Novartis, and Novo Nordisk all filed suits in the District of New Jersey. They were all assigned to the same judge, Judge Qureshi. He held an oral argument for all the cases, all those four that he presided over back in March. And he issued a decision in April in two of the four cases, BMS and Janssen, rejecting the takings and First Amendment claims that had been raised in those two cases. The other two cases raised additional claims, including the excessive fines, the separation of powers, and some APA issues, and those have not yet been decided. The BMS and Janssen decisions were appealed and are now in the Third Circuit. And this will be the first merits appeal considering the constitutional challenges. Briefing on the appeal is scheduled to conclude in early fall, and the parties have, plaintiffs at least, have asked for an expedited oral argument date. Also within the Third Circuit, AstraZeneca filed a suit in the District of Delaware. It was largely an APA case focused on the guidance that's been issued, but there was also a Fifth Amendment due process claim that was included. The district court in Delaware ruled against AstraZeneca in March, finding no standing on the APA claims and no property interest for purposes of due process. That's also on appeal in the Third Circuit, and the briefing schedule has been more or less aligned with the BMS and Janssen appeals, and we expect all of those to be argued together in the fall. Staying in the Northeast, there's also a case in the District of Connecticut that was filed by Beringer Ingelheim, and the judge presiding over that case held oral argument just a couple of weeks ago. It was a pretty lengthy, engaged argument. And once that's decided, that will go up to the Second Circuit. The Dayton Chamber of Commerce filed an action in the Southern District of Ohio That was the only case in which anyone sought a preliminary injunction. The court denied the preliminary injunction on the due process claim, which was the only claim on which it was sought pretty early on. Merits briefing then ensued on all of the claims, and that one is awaiting decision and will go up on appeal to the Sixth Circuit whenever it's decided. And then the last case is one that was filed by the industry group Pharma and some additional plaintiffs in Texas. The district court there dismissed on a jurisdictional ground that is unique to that case because one of the plaintiffs there was a provider, healthcare provider. And so the court said that as a result of that, the case had to proceed through sort of a special Medicare Act channeling provision that limits filing suit in federal court in the first instance. That's been appealed to the Fifth Circuit. It was expedited pretty aggressively. It's already been argued on appeal. And if that's reversed, it'll go back down to the district court in Texas for adjudication of the claims on the merits. So bottom line on the landscape, we should have appeals and hopefully appellate decisions from the Second, Third, Fifth, Sixth, and DC circuits within the next, say, 12 to 18 months. And of course, the next step after that would be the Supreme Court, which I think would not be at all surprising given the profile and significance of this legislation, both as a practical matter and as a doctrinal matter. So please stay tuned. It's still early, and even though it's been going on for a year and a half. And at this point, I'm happy to answer any questions that anyone might have.
Great. Jakob, thank you so much. So first one you answered just in terms of when you think the judge in the DDC case will rule on the motions for summary judgment. But the second one is, do you anticipate filing follow-on as applied challenges to the drug price negotiation program? And if yes, what form might those lawsuits take? And I'm not sure if you'll be able to answer that one, but that's the
Sure.
first
Well,
one.
first on the first question, yeah, we don't know when the judge in DC will act. Judges don't generally tell us in advance when they're going to do that. Hopefully, we hope it will be soon. We have indicated that it is time sensitive and that we hope the court will give it appropriate priority. As applied challenges are definitely possible on a number of levels. I mean, once you get to as applied, you're going to get into a lot of the questions about the way HHS and CMS have done the implementation and whether their implementation is consistent with the statute. That's going to matter more in as applied context and could trigger additional litigation. Once particular prices are set, which will be soon, you could conceivably have as applied challenges based on those determinations. It's a little bit early to say exactly what form those will take, but I think this was just what I've talked about. I would view as the first round of litigation, the facial type constitutional challenges to the statute, but there will almost certainly be more to come.
Great. Another question is just asking for a little bit more information on kind of how the exact dollar amount for the taking is calculated. If you could give a little bit more insight into that, that would be great.
Yeah, that's a good question. It's not something that's been briefed much in the litigation to date because it's almost a second phase. The relief that's been requested on the takings claims has generally been a declaration that the statute effectuates a taking, and then the calculation of what just compensation would be for a particular drug would then be a sort of follow-on determination, possibly in a different court, because there's a sort of special way of going about seeking damages for takings once they have occurred that could happen in the Court of Federal Claims. So there's different ways it can go once you get past the first step. Plaintiffs in these cases so far have been focused on the first step. Is this a taking? Is this a compensable taking? If it is, we can figure out exactly how much will be owed, and that will be a much more fact-intensive question involving potentially experts and others to figure it.
Great. And then someone else wants to know if a manufacturer withdraws all of their products from Medicare and Medicaid, if they still have to pay any tax or penalty.
No, if you're a manufacturer and you withdraw all of your products from both Medicare and Medicaid, again, about half of the market in the US, then the tax is suspended as to you, and then you are not required to enter into any agreements, and you wouldn't suffer punishment for not entering into those agreements. So that is the exit option that the statute provides. There is one of the sort of sub issues that's come up in the litigation is how you take advantage of that exit option. The statute itself says you have to give a pretty lengthy amount of notice before you can terminate existing agreements with Medicare and Medicaid, potentially up to 23 months of notice, which if you sort of work backwards would mean that one would have had to have given notice before the statute was even enacted, which doesn't seem possible. HHS and CMS sort of realized that was problematic. So they have tried to fix that problem by saying they would terminate people on a shorter timeline for Medicare if they give notice of intent to do so. So there's been some litigation about that. But if you manage to do it, then you are not subject to penalties. And the question becomes, is that condition consistent with the Constitution? Can the government do indirectly what it can't do directly?
Great. And then I think there's a question getting at if an incoming Trump administration would be kind of frustrated with all of this, are there options for the federal government to kind of take a different route, or what options would they have to potentially not force this on various companies?
That's a good question. I mean, it is a statute, so it's not as simple as undoing a regulation or administrative guidance, although I'm sure there's some flexibility on the administrative side. But the statute itself sets a lot of this up. And so I'm not sure there's a very easy way around it for a new administration. Although if we win the litigation, that could provide a path.
Great. And I think we're getting lots of questions. So I think someone wanted you to comment on it's their sense that they feel like this is a price control, and kind of is there any precedent for past SCOTUS rulings on price controls?
Yeah, well, in our view, it's not a price control really, because price controls generally take the form of upper limits on what a product can be sold for. You can't sell this for more than X. They don't generally, and we're not aware of any precedent for the concept of requiring access to the product to be provided, which we understand to be a requirement to sell at the particular price to a particular preferred class of buyer, the ones that the government happens to be insuring. So it really doesn't line up well with the historical examples of price controls. Government has sort of been trying, I would say, to make this feel more like a price control, but it's just not how the statute is written. There has been some activity in the context of rent control laws recently, a number of cert petitions seeking Supreme Court clarification of how the takings clause applies to some of these more draconian rent control statutes like in New York. And so that's another area to watch to see where the doctrine might be headed there. But we do think this is distinguishable from those cases regardless.
Great. And then we have two questions about Loper-Bright and your view on if you think that's going to affect and how that might be leveraged in lawsuits challenging the program.
Well, Loper-Bright is a very consequential decision, but probably not in these cases because we don't really have much of a fight about what the statute means. We're really focused much more on whether the statute complies with the Constitution. And that's not really a Loper-Bright issue. So I could imagine it being more significant when you get down to as-applied issues and implementation questions for HHS and CMS, and there are issues where that may be very important, but probably not for the constitutional claims that I've been talking about.
Thank you for providing that clarification. So I think someone else has a question about the physical taking portion of the claims here and referencing the Raisin case that you laid out. And they wonder if the statute works in the same way here or if it's different and if that's a problem for your claim. If you have any thoughts on that.
Well, we do think it works the same way. I mean, in the Raisins case, you have to provide the raisins or else you would have to pay a penalty. Here, you have to provide access or you have to pay a penalty. And the way we understand that is that Medicare eligible individuals are entitled to take the medicines for the discounted price that the government sets. And if we don't provide for that, if we don't effectuate that transaction, that we have to pay a penalty. So we do view it as a physical taking akin to the raisin take. It's not exactly the same, but close enough, I think, for the analogy to work.
Great. And I think someone wants to know, are the pharmaceutical companies required to produce whatever quantity of drugs that the government orders, or can they limit their production?
That's a good question, and it's not really clear from the statute, and it's not, it hasn't really been, hasn't come to the fore of litigation. So that sort of how far does it go beyond, what you have, what you already have on the market, back to questions of production. We haven't sort of explored how far the statute might go in that regard.
Great. And then someone wants to know if the 9 lawsuits don't result in a circuit split, do you think the Supreme Court would still grant cert?
I hope so. I think there's a good argument for it, given, again, the significance of the program to the industry, some of the novel constitutional issues that it triggers. I think that this is the type of constitutional challenge that the Supreme Court would be interested in and view it as part of its role to address, even if the circuits don't see it our way. But obviously, if the circuits do disagree, or if there's disagreement among judges on the appellate courts, they'll make it almost inevitable.
Great. And then our last two, which I'm going to just put together to wrap us up. The first one is kind of, how do you assess the efficacy of the government's arguments? And the second is, what happens if these lawsuits aren't defended in court? Final thoughts on those two.
Well, the government has good lawyers. They always do a good job, but they have to work with what they're given. And I think the way Congress designed this program has left them with significant vulnerability. They have defended it, and that's not surprising. That's their job. But courts will have the final word on that.
Great. Well, on behalf of the Federalist Society, I want to thank our speaker for the benefit of his time and expertise today. Thank you also to the audience members who joined us. We so greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in, and with that, we are adjourned.